Today is Tuesday, June the 11th, 2019. It's 10 a.m. It's my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Bohannon, will you please call the roll?
Ennis Bridges.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Clark McKinney.
Here.
Charles Rahm.
Here.
Robert Shackelford.
Here.
Mr. President, all board members are here and accounted for.
Thank you, Ms. Bohannon. Need to review and adopt the meeting agenda.
Motion to approve the agenda as presented.
Motion made by Mr. Rahm. Do we have a second?
Second.
We have a second by Mr. McKinney. All in favor?
Aye.
Motion carries. The minutes to review the improved May 14, 2019 board meeting minutes. We'll take a moment to do that, please.
I'll make a motion we approve those minutes as they are printed.
We have a motion by Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Bridges. All in favor?
Aye.
Any opposed? Motion carries. Moving on to the legal report by Ms. Pamela Spicer.
Good morning, gentlemen.
Morning.
I'll be handling the legal report this morning. This was previously drafted by Ashley Van Clan, who I know you all realize is no longer with the office. I think you may or may not know that, but she's no longer with the office. I'll go ahead and start on number 1, funeral 2019 030951 establishment. As you will see, this funeral establishment has certain disciplinary history. The summary consists of, this is a consumer complaint alleging that the respondent did not provide the deceased death certificate in a timely manner. In response to the complaint, it was explained that the referenced respondent ceased from doing business November 30th, 2018 and is no longer operating. The response also identified the appropriate funeral establishment that handled the deceased services. In response to the death certificate allegations, the manager of the appropriate funeral establishment explained, number 1, that the complainant met with her a few days before the deceased passed. At that time, they prepared some paperwork. She indicated that the complainant did not have the deceased Social Security number at that time, but he told her he would get it. Number 2, the deceased passed on February 22nd, 2019. Number 3, the manager called the complainant to touch base with him and requested that he provide the deceased Social Security number, but the complainant was unable to provide it at that time. The manager indicates that the complainant advised a close friend had the number. Number 4, the manager called a friend who provided the deceased Social Security number. She added this information to the death certificate. Number 5, on March 1st, 2019, she entered the death certificate information in the system. Number 6, after the doctor signed, she noticed that she had misspelled the deceased last name. She subsequently submitted a signed notarized affidavit explaining the error. Number 7, on or around April 11th or 12th, 2019, approximately 4 weeks after receiving the certificates, the complainant notified her that the Social Security number on the death certificate was incorrect. On number 8, she immediately prepared a second affidavit explaining this error and sent it to Vital Records. On number 9, in early May, she received the corrected death certificate. And then number 10, on May 4th, 2019, she mailed the corrected death certificate to the complainant. Legal's recommendation is to close this matter.
We have a motion.
Motion to approve.
We have a motion by Mr. McKinney.
Second.
Is there a second? We have a second by Mr. Davis. All in favor? Aye. Any opposed? Motion carries.
Number 2, number 2019-027101, funeral establishment. This establishment has some disciplinary history. You can see in the report. And the summary is as follows. On or about June 2018, the respondent establishment suffered extensive damage to the building as a result of fire. On or about January 29th, 2019, a board field representative conducted a routine inspection of the respondent establishment, observing the establishment building had been completely torn down and removed. He also observed a modular office building placed in the parking lot of the removed building. The representative then traveled to one of the respondent's sister locations. At that time, he spoke to an individual, stated that her understanding the corporate owner had intentions to rebuild the respondent establishment, but she could not provide additional details. She also stated the records for the respondent establishment were being kept at one of the sister locations. The representative at that time was able to conduct the inspection of the records. The representative also spoke with another individual at a sister location. That individual informed him again that it was the intention of the corporate owner to rebuild the respondent establishment and that the bids had been sent to local architects, but that the corporate owner had not made a decision. The individual also explained that the temporary modular building had been bought to the premises and was to begin being used and when the furniture arrived. The representative ultimately issued a notice of violation to the respondent establishment for not having a fixed place of business. Shortly thereafter, February 22, 2019, the now former manager of the respondent establishment forwarded an email to the board's executive director in which he had advised that the respondent establishment in an email serves as notice to the corporate owner and to the State Board of Funeral Directors and Embalmers that my name and address with the State Board of Funeral Directors and Embalmers be removed from the respondent establishment. On February 25, 2019, the former manager confirmed to the executive director that his previous email served as a notice of his resignation of manager as it relates to the funeral establishment. As of April 1, 2019, the board office had not received any notification of a new manager for the respondent establishment. At some point thereafter, another manager was appointed, but on April 23, 2019, he also submitted a resignation to be effective May 3, 2019. As of May 29, 2019, the board office had not received either an establishment manager change application or any notification from the establishment regarding construction. Therefore, legal's recommendation is to authorize formal hearing, authorize civil penalty in the amount of $500, and compliance satisfactory to the department with these two matters. One, a fixed place of business by either change of location or closure of the establishment within 60 days. Compliance with the funeral director properly appointed as establishment manager.
We have a motion.
Question. The amount of 500, how was that determined?
Obviously, the goal is compliance, but legal determined that a civil penalty in the amount of $500 would be appropriate in this matter, but it is within the board's discretion to reduce or increase the amount. Obviously, the goal is compliance, which is why we included the satisfactory compliance component in the recommendation, but as you all know, it's within your discretion to increase or state that no civil penalty would be required if satisfactory compliance is achieved.
I also have a question. Do you need to finish the thought, Mr. Ron? If item 1 is addressed by a temporary change of location, for example, if they move the office to one of the sister locations that was mentioned, does that address item 2 then regarding naming a new manager? If there's a manager at the sister location and this location's offices are temporarily relocated while construction is being completed, does that resolve item 2 as well?
If I can have a moment, I believe possibly number 2 has been satisfied since the report was drafted, but let me confer on that.
It's a totally separate location. But I don't think.
I think it would be a roundabout way for them to try to achieve this by moving to a sister location. We do have confirmation that number 2, subsequent to this report being drafted, they are in compliance with number 2. But we would need to bring it back in front of the board, and Mr. Gribble. Sister location or a new location.
Obviously, we have great compassion when someone loses a building due to a fire. But this happened in June of last year, and they've been non-compliant in any action other than verbal action. As far as actually doing something, making any progress toward doing anything, they haven't done that. And if they submit an application for a new location that's entirely separate from their other 2 existing locations in that city, then I will review that for administrative approval as you've given me authority for. But if they submit an application for a location of one of their 2 already existing locations, then we would bring that application to you for you to make a determination whether or not they could or couldn't do that. Possibility that they could just be trying to sidestep the laws by a fixed place of business by attempting to do that. But that would be your determination as a board.
Are they still operating out of that modular building, or?
While we went and made the visit, while we issued a letter or a notice of violation for a warning, and then went back and issued a citation because making no substantial progress toward taking care of that building and putting the building back.
Members of the board, back to my first question in regards to the 500. A lot of times it takes dollars to get your attention. I'm certainly in agreement to the 500 or additional funds if the board so chooses. I would think at least 750. And that's just open for discussion.
I certainly agree, Mr. Rahm. I think that they've had a year at compliance, and they're not in compliance. So I think that they need to have their attention called.
And unfortunately, that's a lot of times that's the only way to get it is through their back pocket.
I'm not sure if 750 is enough, or just make it $1,000. Do we have a motion, or anybody want to put a motion on the table on that?
I'll make a motion that we increase it to 1,000.
Mr. Rahm has made a motion to increase the penalty to $1,000. Do we have a second?
Second.
We have a second by Mr. McKinney. All in favor? Aye. Any opposed? Motion carries.
And I will make the appropriate changes to the legal report. I think we're going to
Members of the board, we have our new Assistant Commissioner for Regulatory Boards with us today, Toby Compton. He has been on board for this is probably the 3rd or 4th week, and I was on vacation the first week, so got to meet with him and get to know him the second week, and it's been my pleasure to get to meet with him and be with him for a nice period of time.
Yeah, absolutely. Thank you all for having me out, Mr. Chairman. I've enjoyed getting to know Robert. It's been really interesting. I have to confess, this particular industry is one I'm not familiar with, and so it's a lot of fun. One of the attractive things for this job to me was learning about new industries. I worked with contractors, architects, engineers a lot, but never burial services, and so I look forward to working with y'all and collaborating and supporting what y'all do for your colleagues in your industry. And anything I can do to help and work with Robert I'm happy to do it, and just trying to get by all the boards and kind of make myself available to you. I think you'll find I'm a problem solver. I try not to cause problems. I try to solve them, and so that's kind of the framework that I kind of work in. And I'm pretty new. I figured out where the bathrooms are so far and where my parking place is. So as I have questions, I may be coming to y'all from time to time. And if y'all have questions of me, please call me anytime. I'll leave my cards, and that way y'all know how to reach me and whatnot. And you can always get me through Robert or Pam, either one, and anything I can do. Any questions y'all have of me?
Questions?
Thanks for stopping by.
Thanks. Well, yeah, no, I think it's
Welcome.
important to do that.
Welcome.
Anyways. So it's a great department, and we've got a lot of really good agencies. Thank you all for your service to the state.
Thank you, sir.
Yeah.
I will pick back up with number 3, 2019-024481 funeral establishment. This establishment also has some disciplinary history. The summary includes that this was a consumer complaint alleging that the respondent establishment has been unresponsive to requests for information on a pre-planned insurance policy purchased over 20 years ago. Specifically, the consumer alleges that it took her 4 days in March 2019 to get in touch with the establishment. She also alleges she did not receive any updates for over a week after the manager of the respondent advised he would get back to her when he returns from being out of the country. Notably, this respondent establishment submitted a letter to the board in March 2019 advising its intent to close, and in May 2019 the respondent establishment submitted the appropriate paperwork for closure. Therefore, legal's recommendation is to close this complaint given the fact that the establishment is closed.
So moved.
We have a motion by Mr. Rahm. Do we have a second?
Second.
We have a second by Mr. Bridges. All in favor? Aye. Any opposed? Motion carries.
Number 4, funeral establishment number 2019-023911. This establishment also has disciplinary history. The summary includes that this is a consumer complaint alleging the respondent establishment misplaced the consumer's deceased baby, not contacted her since the incident. In response, the respondent provided the following timeline, which I will read into the record. The deceased passed on August 7th, 2018. The respondent picked up the remains on August 8th, 2018, and the consumer signed a release to pick up the remains. The consumer elected to have the remains cremated. The establishment staff told her and to her husband that they would need to come sign the necessary cremation papers for the deceased. After a week, the cremation papers were signed. The consumer was informed that the establishment staff would call once the cremation was processed. On August 30th, 2018, the respondent received permission to cremate after the medical examiner was able to get the medical record from the hospital. On September 10th, 2018, the respondent submitted paperwork to the health department. On September 18th, 2018, the respondent was given the permit to cremate. On October 8th, 2018, the respondent received the cremains. Staff spoke with the consumer, informed her the remains were back. She was also told to bring a personal container. On October 9th, 2018, the consumer brought the container. The staff told her to come back the next day. However, the respondent has not heard from the consumer since that time. On March 22nd, 2019, the respondent called the consumer. She didn't answer. On March 25th, 2019, she left voicemail messages for her to call the establishment. Since that time, there have been numerous attempts to contact her, but the voicemail's full and her husband's number is. The respondent also indicated that no one at the establishment had ever told her that the deceased was misplaced. Therefore, legal's recommendation is closure based on these facts.
Has the consumer taken possession of the cremains at this time?
I do not have that information. We can either remove this from the legal report and I can attempt to contact the consumer, but the issue, of course, is we only have certain contact information, and given the length of time this has gone on, likely we would not be able to get in touch with the consumer based on the facts as they are submitted. So obviously,
don't know-
based on these facts, I would have to assume they don't, but it would only be an assumption.
So we're for sure that the establishment does have the remains in their possession or in their care.
No. I'm making an assumption on this based on the facts as submitted. The likelihood of getting in touch with the consumer is probably slim. I can contact the respondent, and we can send out to confirm, because unless Mr. Gribble knows, I don't have any information to tell you where these remains are. I am assuming, based on the facts, that they are still at the establishment.
Make a motion that this particular case be tabled until we can find out exactly where the cremains are.
We have a motion by Mr. Rom.
I'll second.
We have a second by Mr. McKinney. All in favor? Aye. Any opposed? That motion carries.
I think it'd be good if we know for sure where they're at.
What I will do is bring this back to you all at the July meeting with the information.
Okay, thank you.
Thank you, Ms. Spicer.
Number 5, 2019-024321, funeral director. This director has no disciplinary history. The summary is this is a consumer complaint alleging difficulty with obtaining receipts for payments to the establishment for her deceased mother's services. The consumer also alleges that the respondent has threatened to send her sister to collection. In response to the complaint, the respondent indicated the only time she addressed the family in reference to the payments was in December 2018. She also indicated that she was asked to make some collection calls before closing the books for the year 2018, at which time she spoke to the consumer's sister to brief her on the promissory note that they had signed and requested she adhere to the terms of the note. She also explained that if the consumers did not adhere to the note, they would be sent to collections. In support of the response, the respondent provided the promissory note signed by the consumer indicating that they would make monthly payments in the amount of $1. The respondent also provided a chart of payments of the relevant account. While this chart showed the consumers were making payments, the chart also demonstrated the payments did not total the $200 monthly amount. The chart also demonstrated an outstanding balance of $793.23 owed from 2015. Based on these facts, legal's recommendation is closure.
We have a motion.
Motion to accept legal's recommendation.
Motion by Mr. Shackelford.
Second.
Do we have a second? We have a second by Mr. Charles Rom. All in favor? Aye. Any opposed? Motion carries.
We have 2 more complaints to review. Number 6, 2019-034771 is an establishment. This establishment has some disciplinary history. The summary consists of, in this complaint, the complainant, an individual working for the military, alleges his office received a bill from the respondent establishment with irregularities. Specifically, the complainant alleged that the respondent establishment GPL list offering B covers funeral director and staff and other funeral items, but an additional $2,000 was charged on the bill for services of the funeral director. There was also a charge for extra help in the amount of $500. When asked about the charges the complainant claims the funeral director advised, he charged that since he had to field emails and phone calls for over 2 months. In response to the complaint, the respondent indicated the offering B on the GPL covers the basic services of the funeral director and staff. However, given the number of people involved with the planning of a high-profile service at issue, there was nothing basic about it. The funeral director involved with the service was in several meetings for over 2 months, some of which lasted over 4 hours. The funeral director estimated that he was involved in at least 25 hours of meetings for the service, which included changes in the requests made by the military. $500 was charged for extra help because the respondent establishment had to call in all of its part-time workers to help on the day of the service. There were over 600 visitors for the service, and the staff had to coordinate with several different organizations. In addition to the above, the respondent establishment also provided a letter from the deceased nephew explaining that he believed the scope of the establishment services that were rendered were far in excess of a typical funeral service. He was impressed and grateful to the funeral director at the establishment for coordinating all the interest and all the parties involved into what was a moving and meaningful event for his family and the community. Number 3, he conferred with the respondent regarding the bill, found the invoice sum to be eminently reasonable given the totality of the circumstances and the services rendered by the funeral director and his staff. Because of this, he was completely satisfied and paid the invoice in full without question. Given these facts, legal's recommendation is closure of this complaint.
Motion to accept.
Motion by Mr. McKinney. Do we have a second?
Second.
We have a second.
Question. Mr. Gribble, the additional charges that were submitted on this bill, were they not outside the scope of the law?
Possibly. I think what maybe negates that or compares to that is the nephew was the one in charge. He authorized the services, total in agreement with the billing of them, and he was the one who paid. The person filing the complaint was not the next of kin. I think that it would probably be a very intense process to make sure that it was outside the scope of the law. Probably require possibly some coordination and consultation with the Federal Trade Commission regarding the funeral rule to make that determination. Gentleman practice funeral service every day, and his argument is that that's not basic services of funeral director and staff.
I mean, the way this is, I could add extra charge to any service I have because of what I do. I mean, I could say I had to meet with them 5 times.
Personally, it was my hope that the funeral home would take any service that they have to whatever extent it is and do it for whatever price there is on the general price list. Have more people there, then that's more people coming in and out their door that day, and they have a possibility to maybe get business from additional people. But this funeral director chose not to do that, which makes it very, definitely it's a possibility that there's a violation of the funeral rule. Can we easily determine that, or could we determine it through an investigation? And would the Federal Trade Commission make a definitive answer to us? Probably not.
And one thing is the person in charge of the services, evidently by their response and their testimony here, was completely satisfied with the charges, and the person filing the complaint just seems like that they were getting involved in something that they shouldn't have.
And one other thing that, Mr. Rom, that I guess when I was trying to reconcile all this in my mind was the nephew who paid the bill, it's my understanding he's an attorney.
Okay.
So he's-
Why did the military get the bill if the nephew was in charge?
Well, I don't know that the military per se got the bill. I think it was some reimbursement that they were making to the family, and this person at the military, who was maybe a distant relative, then decided to take it upon himself to review the bill. I don't know. At some point, that person who worked for the military saw the bill, and he was the one who filed the complaint.
Other questions or comments? We do have a motion on the table. Mr. McKinney made the motion. We did get a second by Mr. Bridges. Does that still stand, gentlemen?
Yes.
All in favor? Aye. Any opposed?
No.
On the record, Mr. Rom opposed. Motion carries.
The last complaint, number 7, is 2019-04618, funeral establishment. This establishment has no disciplinary history. The summary is, this is a complaint alleging the respondent establishment damaged his sister's grave when he tent for burial services. Specifically, the consumer alleges the respondent drove directly into the sister's grave to hold up the tent. He claims the stake left a deep hole in the grave. In response, the respondent establishment indicated the cemetery caretaker has filled in the hole called. He also indicated that he was willing to sod the grave to help, but the cemetery caretaker advised against it. Additionally, the respondent stated that he did not intend to cause any malice against the consumer or to damage the deceased grave, but there was no way he could have put up the tent for the service without staking it as he did. Therefore, legal's recommendation this matter.
Motion to accept.
A motion by Mr. McKinney. Do we have a second? I heard two
Yes.
people. We have a second by Mr. Rom. All in favor?
Aye.
Any opposed? Motion carries. Thank you, Ms. Spicer. We appreciate that. Moving on the agenda, Mr. Gribble with the director's report, sir.
Thank you, Mr. President. Board members, the first item to consider is the legislative update. We have listed the bills that have been enacted, or the dates that they will be enacted, in the public chapter form. There looks like there's 5 pertinent bills to the Board of Funeral Directors and Embalmers. Those bill numbers and those public chapters are there on your iPads. I'll be glad to go through them, but I know that these are the ones we've been through since the session started back in January, and we started getting them to you at that time. So if you have any questions, I'll be glad to answer those. But those are the ones that passed in the session that ended this year.
Any questions, gentlemen?
Licensee report, as a report of licenses administratively approved by the Executive Director pursuant to the Board authority for the period of May 14, 2019 through June 10, 2019. You have 2 establishments there, one with a new establishment, one with a name change, and looks like 5 individuals during that period of time that were licensed as either funeral directors and or embalmers. Closed establishment report. There's 1 establishment reported closing since the last board meeting. That's Revelation Funeral Home LLC, which was located at 2203 Buchanan Street here in Nashville. And the complaint report, as of yesterday, there were 19 complaints that were against either funeral director and or embalmers, and 29 complaints against establishments, for a total of 48 complaints. Mr. President, that concludes.
Thank you, Mr. Gribble. Do we have a motion to approve the director's report?
So moved.
We have a motion by Mr. Rom. Do we have a second? We have a second by Mr. Davis. All in favor?
Aye.
Any opposed? Thank you, sir. Moving on to the approval of license applications.
There are no establishments to come before you today and no individuals. And also, just to clarify, I know on the agenda, it had disciplinary action report under my part, and there was no disciplinary action taken for the applicable month that I report to. So that was the reason I didn't say anything about that.
Thank you, Mr. Gribble. And we'll move over to the new business.
President, I have two things to mention to the board. One is on your iPad there is, as you're aware, each year about this time that there's a departmental request for legislative proposals that the board might want to consider. You have an email there from Keeling Baird, the legislative director, that explains that process and what's involved in it. And of course, this is legislation that the board would present to administration here at the department for consideration, and then if it passed that test, then it would be submitted to the governor's office for consideration and inclusion in the governor's packet. And typically, this board doesn't submit proposals, but it certainly is if it's something you want to do, it's something we can do. The deadline is very, very soon. We had our board meeting last month on May the 14th, and we received this information on May the 15th to bring back to you this month. But if it's something the board wants to pursue, certainly Ms. Spicer and I will be glad to do the paperwork and the things that need to be done in order to have that submitted in a timely manner.
Any questions from the board members or comments? Thank you, Mr. Gribble.
I assume then that it's okay to assume that there's nothing the board wants to submit. Is that correct?
I have nothing, Mr. President.
Anyone have anything they would like to submit? No,
Thank
Mr.
you.
Gribble.
The second thing, because of our scheduled hearing for next month, of course, normally our board meetings begin at 10 o'clock, but Ms. Spicer tells me that she feels certain that we're going to have a formal hearing next month for a July meeting, so I'd like permission for us to change the time on that to 8:30 so we can do the normal board business at 8:30 and be ready then to do the hearing at 10 o'clock, because it more than likely will be a long day that day.
No problem with me, Mr. Gribble.
Thank you.
And just an update on that, as you recall, I reported to the board last month that I thought a settlement might be possible. It appears that may not happen because I was hoping to be able to report back to you all again today. We have additional depositions set Friday and possibly additional depositions towards the end of this month. So it is likely that we will have a hearing at 10 at the next board meeting.
8:30.
I think your board meeting will begin at 8:30, and then the hearing will be scheduled to begin at 10.
Okay.
But unless there is a settlement, there will be a hearing.
Correct. There are no further continuances. Just by way of update, I did receive a phone call from an attorney that I thought may be getting into the case. However, I never received a notice of appearance. It was my understanding that individual was going to file for continuance. I told that individual that I would not agree to a continuance, and it was my understanding that they were not going to allow any further continuances, and I have not heard from that individual since. However, that individual could enter a notice of appearance, and that individual attorney could request a continuance, and then ultimately, as you all know, procedural matters are heard before the administrative law judge, and the administrative law judge has the authority to grant said continuance. There's some reasonable basis that they deem appropriate for the, but legal would not be agreeing to any further continuances.
Thank you, Ms. Spicer. Any other new business?
one more question about that. You feel confident that that hearing can be concluded in a day's time?
Yes.
Any other questions? Thank you, Ms. Spicer. We appreciate you. It is 10:40 a.m. Do we have a motion to adjourn?
So moved.
We have a motion by Mr. Rom. Do we have a second?
Second.
We have a second by Mr. McKinney. All in favor?
Aye.
Any opposed? Motion carries. Thank you, gentlemen.